Hello, welcome to the inspection process training. We are here with Anisha and Crystal.
Hey.
Hello. All right, so we're looking at dot loop here, and the inspection forms, there's a couple different places that we have to look at for the inspection forms. So one of the things that you can do is again, I had mentioned in another training, learn the addendum names. So the traditional one is called property property inspection. It's not the notice, that's the response. Property inspections addendum. We're going to talk about the notice also.
Okay.
So that's one. Actually, we'll go ahead and talk about that for the moment. Okay, so in the meantime, I do want to talk about where in the main real estate contract, which is sales improved. I don't know why, residential contract of sale, hit copy. Okay. So when you are going through the contract, like we did on the previous training, there is on page 2 right here where it says home and/or environmental inspection. Buyer acknowledges, subject to seller's acceptance, that the buyer at the buyer's sole cost is going to have a home inspection and/or environmental. Okay, so here's the thing. Even if you choose an as-is with inspections option, you still have to do inspections addenda attached. The only time you do inspections declined is if literally the buyer is not going to bring one single person through that house between contract and closing. That's the only time you say declined.
So would an example of that be like an investor?
Yes, if an investor is, you're showing the property and the investor's like, I got this. And the investor knows that he's basically going to literally rip everything out anyway. He's going to replace the, the HVAC and the electrical and put a new roof on, and he's going to gut it to the stud. And he doesn't want any kind of like structural or any type of inspection, then yes, he can say inspections declined. However, I would say that, I don't think you need to, because if you say inspections declined, it also says right here in the paragraph that I can't remember the number, but right number here, number 22, that the property is being sold as is. So the buyer is if they are declining inspections and accepting the property in as is condition, they are accepting the property in as is condition, period. So that's that. And that when you are explaining the main section of the residential contract of sale, a lot of people get really hung up at that clause, which is paragraph 12, where they want to then talk about the home inspection. But I always just kind of, to use my mother's phrase, cool their heels. I'm like, okay, you are going to have an inspection, but there is a 4-page addendum that we're going to talk about in a little bit. So hang on, we're going to talk about that in a minute. Okay. So I don't talk about the home inspection during this because you don't want to get derailed. You have to stay at the residential contract of sale and make it through that first. And it took a long time the other day when we went through it, because it does take a long time and there's a lot of information to absorb. So once you get through that, you can kind of like, we've gotten through the first 11 pages, let's take a breather. So once you get to the property inspections addendum, it is also super important to understand you've gone through and explained about the dates and the times and the contract date of contract acceptance and how you count and compute days and all of that stuff, right? Remember, we talked about this in the other class, okay? So right here, if you're using dot loop, this will autofill for the property, whatever, buyer, seller, yada, yada, yada. This main part, all 4 parties need to initial, okay? So this is what is super duper important to understand. And I'm gonna pretend that we're gonna put in the number 10 Okay, I'm going to read this word for word because it is super important. Do you have to read it word for word to your clients? No, but to be honest with you, it can't get any clearer than this. So sometimes I know this so well that I don't have to read it word for word, but buyer at buyer's expense has the right to have property inspected by a qualified professional engineer, licensed home inspector, or other expert selected by the buyer. Such inspection shall be completed, and in the event unsatisfactory conditions are found, a copy of the entire inspection report shall be submitted to the seller together with a written statement indicating what conditions in the report are considered unsatisfactory and what corrective action is required within 10 days, 7 days, 14 days, whatever timeline you pick. Now, the timeline is important because the whole thing has to happen. All 4 of those things. You have to schedule the inspection, have the inspection, get the report, and create your list all within that one time frame. Okay, so within those 10, now this says inspection may include but not limited to, and this just basically says everything. Okay, if you needed to add something, let's say there is a detached outbuilding or a barn or a shed or some additional thing that the buyer wants inspected, you have to then input that right here in this page. Okay, now we're not going to talk about what happens after that just yet. Now what this does is, this is just the general structural and mechanical. If your buyer is concerned about mold, you need to put in a specific mold test. If your buyer wants an environmental test, now what would the environmental test be? It would be a right here, these are the types of things: paint thinners, UFFI, synthetic stucco, polybutylene typing, mold spores, other items if found. Radon. Radon is a odorless, tasteless, colorless gas that comes from the ground. The EPA has established that anything over 4 picocuries, I do not know what a picocurie is, but it's the EPA's level. It's how they measure the radon gas in the air, okay? Anything over 4 is unacceptable. Right here, again, same thing. If you want a radon, oftentimes the structural mechanical home inspector can run the radon test as well, but you still have to initial this so that the seller knows that you're having a radon test, okay? Now, what all of these different things means is that the buyer is making the contract contingent. This is what a lot of buyers need to understand, that all of these extra addendums are what's called contingencies. Contingencies mean that it is giving the buyer the opportunity to say, hey, you know what? If this doesn't go well, I don't want to buy this house. That's ultimately what a contingency means. And we always have to remember, and I know I touched on this at the other contract training, we always have to remember not to do a lot of realtor speak, okay? So when we throw the word out contingencies, the general public is not going to understand what contingencies means. The general public needs a definition of what contingency means, okay? So now what this also does mean is that if they want to have, let's say, a lead paint hazard, but they don't want to make the contract contingent upon it, meaning like they just want to know what they want to know, they don't have to sign this. They can have the test done so long as the seller gives you permission. They can have the test done, and then they can have it for their own information. Now, a seller may push back and say, look, if you're going to do it for your own information, do it after you've bought the house, okay? In which case, then you have to have that conversation. You're either going to say, look, if you're going to buy the house regardless of what the results of this test is, then just have it after you've bought the house. If not, and you want that opportunity to say, hey, I either want this fixed or rectified, or I'm not buying the house, then you make it contingent upon this particular inspection. So this breaks all this down. So we have chimney, radon. So we as a team typically do have chimney. We have a radon, we have structural and mechanical. If you have, on your visual inspection, seemed something that doesn't quite smell right, or, very moist or wet, or something along those lines, and you want to have an additional mold inspection, you can. The other thing right here is additional inspections. Something that is also popping up a lot is a sewer line inspection, particularly on the houses in the city where the infrastructure is 50, 60, 70, 80, 90 years old. Because these sewer lines are causing pretty significant issues. And so you can have a sewer line inspection. It does cost you an additional like $200 or $300, but it is important in that way because those are thousands of dollars worth of repairs. Okay, any questions, or Anisha, do you want to add anything?
No, not so far. You're doing great. Have at it.
Thanks. Okay, so what I will say is on the additional inspections thing, other than the sewer, you may want to buffer this by an additional 3 to 5 days than your original structural and mechanical inspection, because let's say the home inspector says, hey, you should really get this checked out. If you have your home inspection done on day 9 and you only have 10 days in there, then you would need to get an extension of your inspection contingencies. But if you add that additional, if you add in 15 days and your original window was 10 days, then you have your buffer. Fair? Everybody understand?
Mm-hmm.
Good. Okay. Rights and obligations of the buyer and the seller. So what this states here is that the seller is going to make the property available and accessible for all of the inspections. Okay. But this also says the buyer cannot do any damage to the property in order to do an inspection. The inspection report process. So here's the other thing. So let's talk about what happens after. So you go and you get the inspection done and you have your report and you speak with the buyer, which I'm going to talk about in a second. Right now, I'm just explaining the addendum. You speak with the buyer and the buyer says, I want these 5 things fixed. Okay. That's the list of unsatisfactory items that the buyer has determined based on the report. Okay. There are 2 ways that you can, what I call negotiate this, okay? This paragraph right here is, in my opinion, what I call the sort of as is paragraph, meaning that if the buyer is dissatisfied with the inspections process, then the buyer can just declare the contract null and void, okay? The buyer would need to initial here. Now I want you to read this bold point, okay? If the buyer initials here, well, let me skip for 1 second. This way, so you've got the box, and everybody in the business calls this the box. Okay, so that's just, did the buyer initial the box? That's like the phrase, did the buyer initial the box, right? Because the box is new. The box hasn't always been there. This is how it's been. And basically what this does is you give the list of dissatisfied items to the seller, and then the seller has 5 days to determine, and I'm basically reading this, if the seller elects to correct all, some, or none of the items that the buyer has identified. I'm going to repeat myself. All, some, or none. Okay? Now, if the seller elects to correct all of the items on the list, we're done. The buyer has identified the things that the buyer wants fixed. The seller says, I'll fix them. We're done. If the seller says, I'm not doing anything, or I'm only doing some, so let's say that buyer has come back with 5 things and the seller comes back with 4, then the buyer has the opportunity to say, I either want to buy your house or not. Now that's 2 days from the seller's written response. I'm going to fix 4 of your 5 items. And that buyer then has the opportunity to say, all right, well, you only fixed 4 of the 5. I want out of I'm going to declare the contract null and void. And the seller is supposed to give the buyer back the deposit at that time. Okay. So anytime, the only way that a seller can basically, what I like to call, hold the buyer's feet to the fire, is if they accept the entire list as it is and fix everything. As a listing agent, my goal is to hold the buyer's feet to the fire so that we can hold on to the buyer that we have. Trying to resell a house after a home inspection is always difficult because all the new buyers are going to say, well, why did it fall out? And then you're going to have to say, well, we didn't agree on the home inspection. Oh, well, what was wrong? Okay. This creates fear and uncertainty in the new buyers. Okay.
Can I interject?
Pardon me?
Can I interject?
Of course.
So when she said, the reason why when you start asking for all of these inspections, the more inspections that you ask for, the seller, if this deal falls apart, that's why she said it's important to keep the deal in place. The seller is now obligated, if they find out some damning information, to disclose that information.
Right. Remember our property disclosure disclaimer laws, although we should probably have that'll be next week's training.
Right. So if you have too many inspections and things come back bad, then the seller's obligated to disclose it. So that's why they're leery of unnecessary inspections, because it then puts a burden on them.
Right. So real life example is the Wiley Oak house that I'm dealing with right now, where the buyer had a stucco inspection, and I say stucco in air quotes, and the stucco inspection came back, quote unquote, that the stucco was, installed improperly and needed to be completely torn off and redone, right? And the seller, I represent the seller is like, well, can't we just make this go away, and screw them, so to speak, right? And I'm like, that's fine. They can go away. But we're now still dealt basically a hand of cards that we now have to manage, because we have a report on our hands that says this stucco is faulty. So we now have to address it in some way, shape, or form with proper documentation that says okay, it's faulty, we fixed it, here it is, right? But we can't just say to the buyer, go take a hike, and then not address the stucco issue. Does that make sense, Crystal? She said yes, but she's muted. Okay. So now let's go back up to, so you understand that the seller, this way is the traditional way. So if you don't initial the box, the buyer has to submit a list. If the buyer does not submit a list within the original time frame, the buyer is deemed to have accepted the property in its as-is condition, and they waive their right to ask for anything. We're done. If the buyer submits a list, then the seller has 5 days. Let's say the seller doesn't respond. Then the buyer still has 2 days. So if the seller doesn't respond, elects to correct only some or none, then the buyer has 2 days. Now, sometimes in that 2 days, the buyer can do their own due diligence and say, hey, you know what, this isn't that big of a deal. I can take care of this on my own. And they go ahead and accept the property as is. But within that 2-day time frame, they have to either have come to an agreement with the seller, or at the end of that 2 days, then if they don't want to buy the house, they have to send in the release and elect to terminate the contract right here. Okay. There is a credit option, meaning that the seller can say, you know what, I don't want to fix this, but I'll give you money. Okay. That is on the thing. And I'm going to show you exactly that form when we're done. Now, right here, repairs, correction, and reinspection. Seller agrees to complete repairs and provide receipts in sufficient time for buyer to inspect prior to settlement. Now, paragraph 22 says the buyer has the right to inspect the property within 5 days of closing. So that's typically when this reinspection happens. A decent home inspector will come back and reinspect the items that were repaired. Typically, huh?
For a small fee.
For a small fee, what, like $100?
Usually like 150. Yeah.
Okay. And then here, if buyers or buyer's agents, contractors damage property during this exercise.
Have you ever had that happen?
I haven't. Have you?
I had a guy drop like a vase in a frame off of a shelf when he was climbing up a ladder.
Oh, did he?
He went in his pocket and paid for it. Thank God it wasn't a Ming vase or something.
Right. Okay. Let's go back to this box. Okay. This is a negotiable term. It is very important for people to understand. If the buyer decides to initial this box, which in my opinion, I don't recommend. And the only reason why I don't recommend it is because This still says, hey, if you have a list of things to fix and the seller fixes them, then why wouldn't you want to still buy the house, right? This just gives the seller, in my opinion, an opportunity to make good on what the problem is. And if they don't want to make good on it and they don't have to, then the buyer still doesn't have to buy the house. So the buyer still has it, okay? But if the buyer wants to be able to just kind of declare the contract null and void, then, hold on. If the buyer wants to declare the contract null and void after the fact, after the inspection, then they're going to initial here. If the seller says, no, I want to be able to have an opportunity to rectify the problem, they are going to strike the paragraph just like that, literally strike the paragraph, strike through, and then the seller is going to initial outside of the box. It's a very specific process on how this works, okay? So let's say you present an offer, full price, conventional financing, but the buyer has initialed this box, okay? And the seller accepts the offer, except they cross this out and initial out here. That is a counter offer. It is very important to understand that this is not a small thing. It's a very big thing. And it is right here. Which deletion shall be deemed to be a counter offer by the seller for buyer to accept? If the buyer wants to dig in their heels, then you don't have a deal. Even if the seller has accepted the price, the terms, the settlement date, everything else, if they don't agree on this box, you don't have a deal. Super important to understand. Okay? All right. So I'm going to go back here. And then right here, this property inspections notice, this is the document that you use to submit your list of dissatisfied items, okay, or undissatisfied. So you identify the inspections that were completed, notice from buyer to seller, buyer gives notice. So the thing that's super important is using all of these documents because everything is linked together and it ties it up nicely. Buyer gives notice to seller. Again, here's that option, buyer elects to terminate. Note, buyer shall only have the right if the buyer and seller have agreed in paragraph 4B, that's the box, okay? If the box has not been agreed to by everybody, B is not an option, okay? Typically it's C, they check C right here, and then right in here you start typing your items. If there are too many items to type, you can use, well, first off, there's a second page, number one, or if you need to add a page, you can add a page, okay? Right here is where the seller has their 5 days. They're either agreeing to complete, they're not agreeing to complete, or they're agreeing to complete some but not all. And or the credit right here. And then this is where the buyer has their 2 days to accept the seller's response, accept the seller's offer for the credit, or the buyer is going to terminate the contract. Okay, it is very cut and dry. All of the timeframes are specified. It's kind of foolproof. Now, I am going to say that as a new agent, if you're watching this, if you're a new agent on our team, if you are whatever, your first 5 home inspections need to be approved by me, Randy, or Anisha before you submit them, because the home inspection is the #1 place for complaints and lawsuits. So you have to make sure that you are following your timelines and that your inspections are whatchamacallit. What am I trying to say? The wording for the request for repairs is clear, concise, and doesn't give the seller wiggle room to be able to do something that is cheap, basically. Okay, so let's talk about, I'm going to talk about another way that you can do an inspection that is in a competitive situation and that is this as-is addendum. Okay, now as-is sounds really scary, but the way that this one is worded is, it's honestly very similar to the box, okay? So what this is this is basically saying that the buyer is accepting the property in as-is condition. And you have two options here, and I'm going to get to this bold in 1 second. Okay, and the bold is really what tweaks things a little bit. So right here is as is without inspections. That's where an investor's like, you know what, I'm buying the house regardless. So they're going to decline the inspections on paragraph 12, and then they're going to right here initial. Okay, the next one is as is with inspections. Okay, this is where I'm going to call this more of like a feasibility study, meaning your buyer is going to do whatever inspections they want to do, and they're going to do it within a certain time frame, and they're either going to buy the house or not. They're not going to ask the seller to fix anything. This does not allow for that. Okay, they can have their inspections and they can have their out. Okay, but they cannot ask the seller to fix anything. Now, what changes? So in the main contract is the wood destroying insect inspection. The main contract on a traditional home inspection sale, the wood destroying insect is independent of the property inspections notice. That happens regardless. However, if you do an as is, right here, wood destroying insects, paragraph 19 are deleted from the contract, meaning that you no longer get, now you should still have a termite inspection within your time frame, but the seller is no longer automatically required to do any wood destroying insect remediation on the as is addendum. So that takes that out. And then anything pertaining to paragraph 22, which is property condition, which also states that things must be in working order, that's also deleted. Okay, so what this does is if you're in a competitive situation, and this is what I did on the Westview deal, is they did as is with inspection. So they're still able to have inspections, so they know what they're getting into, and they have to have a comfort level to say, okay, they know they're not asking the seller, but we were against 3 other offers, and I know this helped win it. Okay.
But one thing I would say with this form that is a thorn in my side, when you use .loop to autofill your documents, it is going to default to paragraph A. So make sure to
change it,
to change those initials and move it to B if your client is intending to have an inspection with the option to terminate if it's above or beyond their comfort level. Because when it defaults to A, if you are not paying attention, you have put your client in quite a quandary. So just make sure that you're paying attention.
Exactly.
I'd rather it just didn't even put an initial anywhere than defaulting to A. A is like the worst of the two.
Exactly. Okay. Not Sharon, Crystal. Questions? No questions?
Did she hit unmute yet?
She didn't unmute because she's saying no to questions.
Okay.
Other than, I don't want to, I'm going to break this up from a training module perspective. There are additional addendums that go for lead paint. If you are on a more rural or suburban that has well and septic, you're going to have additional addendums there. Or if you are in other counties, you may have other addendums for other inspections. We will do another training module for the what I would call auxiliary inspection addendums, which is what is required. So for that is specific to each contract, depending on the house. So, okay, I'm going to stop sharing and stop recording.